Blake.
That's a good thing, because all of they stay here until it's done.
All right.
Hey-o.
This is civil case, Matheson versus Matheson. The fourth court, the petitioner's motion, which is entitled Motion to Modify and Reconsider.
Yes, sir.
It, having reviewed the file, it appears that the party failed to appear for trial, and the court heard evidence and entered judgment based on the information heard at the trial. I suppose giving the defendant, or given the petitioners the benefit of the doubt, this is really more of a motion to set aside a default. Or I guess it can be considered as a motion to reconsider. The court would also note that other than the motion, the affidavit filed in support of it simply recites the basis of the motion, as a practical matter, sets forth no factual findings or no factual allegations.
Are those redundant typically? If I'm pro se and filing in a motion and an affidavit, would that be redundant in a sense?
Well, as a practical matter, appearing pro se, you're held to the same standard
For sure.
as an attorney. Are you ready to proceed then?
Yeah, thank you, sir.
Mr. Matheson, you proceed.
Thank you, Your Honor. We had a trial set earlier this month, and I had not received any sort of notice for the time and date, and I understand the pretrial date, a notice was on there as well. So I've been following the repository to get my time and date stamps for set court dates and trials and hearings and things of that nature. And I may have inadvertently looked at the wrong time, but usually I've got a piece of paper stuck somewhere that I can look at and know when's game time. And I just happened to show up 2 hours late. I think it was for the, I was looking for a 2:30 appointment with the a hearing. And in fact, it was held at 10:30 if I'm not mistaken.
Further then?
To We do object to the request, as the court may imagine, and I'm not sure how to characterize the motion. As far as the motion to reconsider is concerned, the record is set with information that my client introduced, and therefore I don't know that the court really could reconsider the decision based on the fact that the evidence that was introduced came in unrebutted and unchallenged in any form. So I think it is more akin to a motion to set aside. Your Honor, Judge Harris spoke of these issues at the time of the hearing, spoke of the fact that the address had remained the same throughout the notices have been sent, that this respondent has shown up at the pretrial conference, and the trial date and time was spoken of at the pretrial conference. And so all appropriate notices were given. I can understand inadvertence, but when it comes to trials and the amount of time and preparation that goes into it, the fact that the evidence was introduced in this case means that the result remains as is. Judge Harris made very sure to look and be certain that Mr. Madison received appropriate notice, and I know that this court can follow the same as Judge Harris did, but the address has always remained the same. The notices were sent. He did appear at pre-trial. We spoke of the trial date and the time. The fact that I'm back here again is another financial disadvantage to my client, which is not appreciated. There's no factual basis set forth in the affidavit, so the information that comes before you is not under oath as far as factual information. And so we object on that basis. Say this case boils down to one issue, and it was brought up with Judge Harris. All that we requested is for the respondent to submit to a hair follicle drug test at a location of his choosing, and if he tests and he comes back clean, then we would immediately start visitation. That's been the issue for a large period of months, and I'm sure the respondent can respond here, but in speaking to him, I know that he believes that somehow we have brought about a false positive in a test that he previously submitted to. It was attached to our petition, and it was spoken of at the default. Well, and I won't even call it a default hearing. It was the trial. He just merely failed to appear, so it really wasn't a default. We had the trial, and the result was obtained. There is no default. It just wasn't present. But our concern, Your Honor, is that this respondent tested positive for 4 separate controlled substances immediately following the last trial, not this trial, the one prior to that. And a large period of months has passed in which all that we request is for him to submit to drug testing, and I think that he's under the impression somehow that I'm bringing about, my client's bringing about, that someone has to outform him and is causing him to test positive.
Wow.
So that's our position, is the result should stand, and even today, as in the last several months, repeatedly over and over again, we set forth that if he would submit to a hair follicle with a location of his choosing, we will even pay for it anywhere in the hospital. Advanced drug detection, Weinhoff and Burley, go to Boise. We don't care. As soon as we get a clean test result, we'll begin visitation for the children. But that hasn't occurred, and he's refusing to test. And so we stand firm, and we strenuously object to any reconsideration. I don't think there is anything to reconsider. As far as reopening it, that doesn't accomplish anything. The mere fact that the case is reopened doesn't accomplish anything. The motion's improper, there's no factual basis, and Judge Harris had good reason for the order that was entered, so we object.
Mayor Butte on that.
Any response?
Yeah. So I'm curious as to what type of evidence was heard at the last hearing, and as far as the Daniel lists a lot of things there. So if we want to talk about as far as what my intent is to fight for my kids. That's why I showed up to the pretrial, conference. That's obvious that I wanted to be there and why I wanted to follow through. If I don't get noticed, then I can't obviously understand or know when the trial dates are. I understand that they were attempting to shift some things around and couldn't for my daughter's birthday. I was waiting for any sort of notice on a trial date change. Daniel makes things so trivial. We've been at this 3 years, and we're talking about one hearing that I just happened to didn't get information on and I couldn't show up to. That's completely trivializing my children's life and the distance that's been caused between myself and my children from the courts. Everything has been brought, as far as evidence, is malafidus. I mean, everything. You want to talk about comparing, anybody who does any sort of the preponderance of evidence would have seen that the form or the evidence that's brought up against me is void. And if Daniel wants to make assertions as to what my opinion is, I'll make an assertion here as well. that he even agreed with me that these tests were, these tests they looked a little fishy. They looked a little cooked. Something was incorrect.
The timestamp is incorrect. That's the only thing that's incorrect, and that doesn't invalidate the test.
Sure.
That's my position.
If it confuses the evidence, if it muddles the water, what is that? What is evidence then? What is the whole point of what you would argue as evidence? Or a judge even looking at something that's fake?
I understand.
Just because I say China and Russia are next to each other, that doesn't make it true. Yeah, Your Honor, I just wish that I had proper notice, because I'm more than happy to come and get dressed up and present my case and have to continue on with this continuous litigation. That's my rebuke to his information as far as what he believes that needs to occur here. What needs to occur is stare decisis. We need to go back to where there was some sort of a formal compromise, where she and I could formally communicate, and there wouldn't be some sort of, burden on Shyla to want to talk to me, because I'm just this guy who's, intruding on her children's well-being.
Well, as the court noted, the plaintiff respondent in this case is being pro se. Viewing this either as a motion to set aside a default or a motion to reconsider, under the rules, he has failed to make any kind of showing whatsoever.
May I object to that?
On either view of the motion, he's required to submit a pleading which sets out facts upon which the court can make a determination. No facts have been presented.
May I object on
This,
Yeah, I'm sorry. I didn't mean to interrupt, sir.
this is totally frivolous. I'm denying the motion, and counsel, if you will submit an appropriate certificate under the rules, I'm awarding attorney fees for bringing this out.
Objection. Point of clarification. So what you're stating is
You have not complied with the rules.
I'm sorry, I didn't mean to interrupt you. I haven't stated any sort of clarification.
I'm denying the motion, and I'm awarding attorney fees and costs because this was brought frivolous.
The attorney's fees and costs of this particular hearing, is that what you're stating? So I object, may I again attempt to state the rule of law. Where am I supposed to understand? You think Jerry's going to give me the information? I'll stand. You think Jerry's going to give me the information, sir?
You have chosen to be your own attorney.
Not by
Idaho
choice.
Supreme Court says
Man.
you are held to the same standard as any attorney.
But yet I'm trying to, objection, point of clarification, I'm trying to state some things to you and you keep cutting me off. And I'm trying to get an understanding, a full understanding, clarification of why it is that the rule of law has boned me, because they want to frivolously try to litigate best interests of the children. Trivialize this for me, please.
I've already explained to you.
Yeah, you trivialized it.
You haven't complied with the rules.
The rules are hidden. The rules are privilege.
The rules are not hidden. They are not privileged.
Yes.
You chose to be your own attorney.
I had to,
and
choice.
The Supreme Court says you are held to the same standard as an attorney.
And the Supreme Court that says nobody shall interfere with parental rights, the parents' rights to their children. Is that correct?
Well,
And then you are doing that.
that's not an accurate statement.
Oh, it's not? Okay. So let me just do this. Parental rights may not be taken away without clear and convincing evidence, due process, and strict scrutiny. Now, you're telling me...
That occurred in this case. Look, I'm not going to argue with you.
I'm not trying to argue with you. Objection, point of clarification. The decision is
It's done.
Unfortunately, Your Honor, objection, point of clarification. You're not allowing me to speak and present my case. I'm not trying to argue with you, sir. I'm attempting to make a clarification and ask you if you're terminating my parental rights based on this trivial
I have
assumption that this is frivolous.
There is nothing that terminates you.
Well, you're doing that essentially here, my friend. That's you're telling me that I have to go through this whole process again, and we'll do another 3 years.
Sit down and be still.
Your Honor, I'm still addressing the court.
You sit down and be still, or I will have the
Objection, point of
bailiff-
clarification.
Do you want me to have the bailiff remove you from the courtroom?